The next case for argument is U.S. versus Vernon Wood. Mr. Todd.
May it please the court, Mr. Wood, along with his trial counsel, Ms. Catherine Shea, Ms. Cindy Bembry, and I ask this court to reverse the district court's 4248 commitment determination. There are two grounds for this request. First is the fact that the categorical prescription on any type of communications with the respondent selected examiner contradicts due process and is contrary to 4247.
Let me interrupt you right there.
Yes, sir.
Mr. Wood could have appointed a non-testifying expert to assist his counsel and him with preparation of that defense. Why didn't he appoint that non-testifying expert?
He could have, but the point of our contention is that the government always has one person, the BOP expert, who has access to the respondent.
I understand it, and that was the psychiatrist, I take it, from FCI Butner.
Yes, Your Honor.
Well, this goes directly back to my question again. Why didn't he appoint a non-testifying expert to consult with him and his attorney in preparation of his defense?
First of all, I don't know that he in fact did not. There's nothing in the record to indicate that they did consult with a non-testifying expert. Why they did not request the court for one, I think the point was that they wanted Dr. Sala, who was going to be able to testify, who was going to be able to present evidence on Mr. Wood's behalf, to be the one that they could consult with so that they could adequately prepare, not only so that Dr. Sala could effectively present his opinion.
But they could consult with him, couldn't they?
They could not. They were barred. They were barred by the standing order, which.
Sure about that?
Yes, Your Honor. They were barred.
Both sides were.
Yes, Your Honor.
No.
There's a categorical bar.
I thought there was an ex parte consultation that was barred.
Yes, Your Honor. That's correct.
That was my question. I said they could consult with him.
Well, they could. The only thing they were allowed to do was have a deposition at which government counsel was present.
Right. So. In your argument that ex parte consultation or communication is not allowed, isn't that your argument?
That's the standing order's categorical.
Is that your argument, though? You don't argue you can't talk to him. You could talk to the witness in a deposition or in the presence of the government lawyer, couldn't you?
Yes.
So your argument isn't that you could not consult with him. Your argument is you cannot consult with him ex parte.
Yes, Your Honor. Well, that's part of the argument.
What else is the argument?
Well, the argument is that currently the categorical bar on ex parte communication with the respondent selected examiner creates a skewed playing field in every case. That's
the result of your argument about the rule, though. Maybe I'm surprised. You're surprised by my question. I thought your argument is the prohibition on an ex parte communication with that person. Isn't that your argument? That puts you at a disadvantage, the lack of ex parte communication.
Well, that's part of it. The other part of it is the fact that in every 4248 case, because the BOP expert is not subject to any of the limitations on the standing order, the government has one person that can do all three. And at least
are you entitled under due process, are you entitled to the appointment of a person, a testifying witness that you can consult with? Are you entitled to that?
In a 4248 arena, we would say yes, Your Honor, for the reasons stated in our brief, because of what is at stake.
Under the Constitution, I ask.
Yes, Your Honor.
Not under the rule, under the Constitution. Are you entitled to the appointment of a witness that you can consult with?
Yes, Your Honor, and that's the argument in our brief. First of all, is the fact that as it's played out in the Eastern District of North Carolina, which is where all of the 4248 commitments and determinations are made at this point, the standing order, which basically puts aside previous practice under the rules of civil procedure, and imposes this categorical bar on any type of ex parte communications with someone who can examine the respondent and testify at court. The standing order,
applies equally to you and to the government, correct?
to the extent they want to talk with the respondent selected or the court selected examiner, it
And
does
that's
not.
what we're talking about.
Well, what creates the skewed playing field is the fact that the BOP expert can always do all three. And as the government concedes in their brief, the BOP expert is not subject to the ban on ex parte communications with either the court appointed or that creates a skewed playing field for many reasons. And that's why it's not solely the limitation on ex parte communications. We would say that's contrary to practice, at least in the Eastern District. Anecdotal evidence from Mr. Dubois on down, everybody that's done 4246 practice in the Eastern District, which 18 U.S.C. 4247 applies to both 46 and 48, everybody on both sides was always free to pick up the phone, call the BOP expert, whomever, just to ask questions, to probe things. The standing order changes that. And my question is...
I don't want to harp on this, and I don't want you to concentrate on it, but the playing field would have been leveled had he appointed a non-testifying expert.
It would not for that reason alone, Your Honor, because it's non-testifying. And the standing order, which applied up until the amended one, which was just filed on the 21st, you had three different people. You had your respondent selected examiner, which you could not talk with, except in a deposition or at trial. You had a non-testifying expert who could not testify in front of the district court judge.
But that non-testifying expert could consult with the attorneys and help prepare the case.
It could, Your Honor, but for purposes of the commitment hearing, you want somebody on the stand that's testifying that the judge is going to rely upon to make a determination. For instance, in this particular case, consultation with Dr. Sala could have helped.
In the real world, why is it important? Why is it important for the defense counsel to talk to the testifying independent expert, ex parte? Why is that critical? You can talk to him. You can talk to him or her, but why is it critical for the defense lawyer to be able to talk to that testifying witness ex parte?
Well, I would ask the same question of...
You have to answer that first, though.
Why is it critical? Because this system, Your Honor, and the Supreme Court has said...
I know it's an adversarial system, but why, in the real world, why is it that you talking to them in the presence of the government won't suffice? Tell me why that's so. Because
the decision at issue, which is a district court's determination of whether a particular diagnosis and whether a particular predilection should require indefinite commitment.
I know all that, but why is it critical? What is it that a defense lawyer wants to ask, talk about? What is it that can't be done except ex parte is what I'm asking.
Because that's the way we litigate things in the civil arena. And if this is a civil arena, which we contest it's not, but if it is, the same way any other civil litigant would prepare his or her case is the way it should be done here. And part of that is...
through deposition beforehand. This examiner was to be a neutral examiner for the court.
Well, we would say that under the statute 4247, it's a respondent-selected examiner, and as Judge Gertner from the District of Massachusetts said, the designation of a respondent-selected examiner under 4247 strongly implies that that examiner should be under the control of the respondent, or at least more so than the court-appointed examiner. So we would say that the statute itself would not necessarily support saying it's the court's expert.
If you don't have, just go with me on this first part of this question. If you don't have a constitutional right to an appointment of such a testifying witness that you can ex parte, if you don't have a right to it, such a witness, constitutional right, then how is this a due process violation?
Well, I mean, the constitutional right comes from the application of procedural due process to the way in which
I
4248.
know, but if you don't have, do you think procedural due process under the Constitution guarantees the right of such appointment of a witness to help you in this case?
Yes, Your Honor, given the fact, once again, given the fact in the 4248 commitments hearing in the Eastern District, given the categorical bar, that doesn't apply to 46.
Then I want to go to what the rule does in light of the constitutional requirement. I said my first question is, do you think there's just forget the procedure, forget the rule about appointment, the appointment, standing order, anything about appointment of experts. If there was no such rule, do you think the Constitution guarantees your client under due process the appointment of an examiner to testify for him?
Yes, Your Honor.
Okay. If the Constitution doesn't, then you don't have a due process violation, do you?
Well, we don't have a due process. We would say under the rules of civil procedure
Right, but no
and
due
under the
process
statute.
violation.
Right. The fact that the BOP...
By the way, let me take you back to Judge Thacker's question. In answering her question, your response was that this witness really isn't neutral? That's what you suggested some judge somewhere said.
No, by neutral, I mean, first of all,
Her question was, I'm going to paraphrase it if you allow me, this is supposed to be a neutral examiner appointed by the court. And she also suggested, and you can talk to that person in deposition. So what's wrong with that? Your answer was this person, I took it was, maybe I misunderstood you, that some judge in Massachusetts has said this witness really isn't neutral. It wasn't that your answer?
no, I mean, to correctly cite Judge Gertner, she says 4247 can be read to mean that there's...
Okay, well then,
So-
take that back from your answer. Now answer Judge Thacker's question. This is appointed as a neutral witness. What's wrong with saying neither side may ex parte the neutral witness because I want everything done above board and in the open with my court witness. What's wrong with that?
Well, first of all, it can be a neutral witness in that it's an expert who's going to come up with his opinion based on his expertise. There's nothing a lawyer that's going to say to that person that's going to change that. But once the opinion is issued and it's favorable to the respondent, we would say that the fact that it's a respondent selected, it's the acknowledgement that, yes, the respondent is the one that's facing this determination which stigmatizes and puts him in prison-like conditions for the rest of his life. That person needs someone to help prepare, to have a meaningful opportunity to prepare for and present his case
I know that.
against
That's
commitment.
Judge Hamilton's question. You can get a witness,
But
not a
that
witness,
person
but you
can't
get an
testify.
expert that you can use to prepare. That addresses that. Then you still haven't answered Judge Thacker's question. What's wrong with the court having a neutral witness that the court wants to hear from? So the court, in the real world, people can find experts to say a lot of things, and the court finds someone the court appoints as to help the court and says to both sides, I don't want either one of you trying to influence this person at all. I want to know what this person wants to say. You can both talk to him together, but no private conversations with him. Go get your own expert to help you if you want to. But this is somebody that's neutral, and I want to help me. What is wrong with that?
Well, first of all,
By the way, I understand completely. You may not like it, but what's wrong with that?
well, it's contrary to the way we litigate cases in this country under the rules of civil procedure. Secondly,
Did you object to the appointment of the expert for your client?
the respondents selected?
Yeah.
Did we object to that? No, we asked the court for the opportunity to consult with that person prior to
I
that person
understand that,
testifying.
but under Section 4247B, the district court designates an examiner chosen by the respondent.
Yes, Your Honor.
So apparently, if I understand that correctly, you didn't have any, or your client or you didn't have any objections to the examiner that was appointed by the court to represent the respondent.
No, we in fact, we wanted to consult with that person before that person took
I
the
understand
stand.
that, but answer my question.
We
You
did
didn't
not object.
to the appointment of that expert.
No, what we objected to was the refusal by the court to allow us
All
to
right.
talk
So
about the
I assume that you were satisfied with the expert that the court appointed for the respondent.
Yes, Your Honor, what we're not satisfied was the ability to prepare with that
Ban on ex
person.
parte communication, I understand.
Would also say the same question to the government, you know, if they're willing to say their BOP expert cannot testify in court, so it is an equal playing field. And we're not asking for the only one for ex parte communications. They can call up the respondent selected, they can call up the court appointed. But they must see a benefit to having a 3-in-1 expert.
Well, let me ask you this much. Isn't that doesn't seem to me like that's a violation of due process. It seems to me that's a violation, not a violation, but the rules of economics. The government has resources. The government's going to appoint witnesses. The government's going to do that.
And that's part of our...
Which, by the way, you can do it too. You can do it too.
Well, in the age of sequestration, it's becoming more difficult for the federal defenders to do that, but
there's
the
no constitutional bar to you doing that.
that is the component of our due process argument, judicial efficiency and efficient use of resources.
There's no constitutional bar to you appointing somebody that you can call as a witness, and you can ex parte all you want to.
But that person under the standing order could not examine our client. That's why the standing order made 3 separate people, a
wait a minute now.
non-testifying consultant.
Do you say the standing order prohibits you from getting your own expert?
It prohibits us from getting a 3-in-1 expert that can examine our client, that consult with us, and can testify at court. Now, the standing order...
You pay for yourself, you can't have that?
Well, that's why I submitted...
No, I'm just asking you that question.
It
If
appears
your
that-
client has the money, does that rule bar what I'm talking about? That
No.
you have the money, you hire, your client does. Your client hires an expert, that expert examines him, you as a lawyer can then ex parte that expert. Are you saying that expert cannot testify?
Under the old standing order, that's what the old standing order prohibited. Now, the amended standing order that came out on October 21st does allow that Rule 26 3-in-1 expert. But under the old standing order Mr. Wood went through, it did not.
You could not have had your own resources, not any expert on the rules paid for by the government, paid for by yourself. You couldn't have such a testifying witness.
Not that could do all 3, once again, like the BOP expert can. And that's sort of why it was a skewed playing field. I only have 26 seconds. I did want to basically say that the main reason for vacating this conviction...
I don't know that you have 26 seconds. You may be over.
Oh, I'm sorry. I'm sorry. I'm reading backwards. Sorry, Your Honor.
But you have 3 minutes.
Then I have 39 seconds less on rebuttal.
Thank you for telling us. Okay. No, we'll give you 3 minutes when you come back up. Mr. James.
Good morning again, Your Honors. My name is Michael James. I'm an assistant United States attorney, and I represent the United States in this matter. Judges, let me first answer a couple of queries that you made to counsel. First, let me begin with you, Judge Shedd. You asked counsel initially, Judge Hamilton. Judge Hamilton, you asked counsel initially if they had the opportunity to consult with a Rule 26 B4D expert. And they did. And counsel's response was...
That would be the non-testifying expert.
That is correct. They had that opportunity. Now, counsel stated he didn't know whether or not they, in fact, had done so. The record is not clear. If they had, in fact, done so, and they chose not to move the court to have that person, A, examine Mr. Wood, and B, testify at trial, that was on them.
So they could have done that?
They could have done
what you're
that.
saying? They could have had someone that could do all 3?
They absolutely could have done that.
If they had moved the court?
Absolutely. And in fact...
Assuming that was granted?
Assuming that, and in the practice, and I've tried a number of these 42, 48 cases, it in all likelihood would have been granted. And that practice, as delineated in the new standing order, if I may just quote it here, and it was filed as a part of the supplemental.
Well, quite frankly, I think the other side said their experience or practice or understanding of the rule is that, quite frankly, you're wrong about that.
Well,
a person could not do that under the old iteration of that rule.
If I may quote from the amended standing order from the district court judge, who addresses that. It says, in addition to another
What
change.
page are you on there?
This is, Your Honor, this was filed on
Yeah,
the
I have
28th.
it.
It's on the first page, second paragraph. It begins, in addition, the court is adding two sentences at the end of paragraph 5D. That's the section that we're talking about, the Rule 26 type expert. Delineating the right the respondent already enjoys under Standing Order 11 SO4 to designate as testifying expert witnesses examiners initially retained as non-testifying experts pursuant to Federal Rule Civil Procedure 26B4D, and to have substantive ex parte communication with such examiners. Then the court points out, it cites United States versus Coyle, and in the United States versus Coyle decision, in that case, the Standing Order reiterates what was stated in the Coyle decision, that this is a right that both parties have with regard to Rule 26 type experts. They can retain those experts. They can move the court to have those experts conduct
Retain them, you mean the government pays for them, or they retain them privately?
Well, we have in our thing.
Which is it? I'm just asking you. Are you saying it's the court, it's the government paid for witness that can?
I believe that would come out of, on the respondent side, out of CJA funds.
Well, that would be government paid
Yeah.
for, wouldn't it?
Yes,
Or is
that's
there more
correct.
than one government paying for this? I
Well,
don't think so.
Well, I think not to get into the weeds, Your Honor, but in the Standing Order, it makes reference to the Gaucher. In that case, talks about DOJ funds versus CJA funds. That's
My point, listen, I'm making a distinction. I'm making a distinction between something that the defendant would have to pay for, criminal defendant, would have to pay
Right.
for himself
No,
out
he
of
would-
his pocket.
He would not. Your
That's
Honor.
the distinction. And I guarantee you this, you say you do this in the real world, I'll bet you that defendant doesn't much care if DOJ pays for it, Homeland Security pays for it, they don't, or CJA, they don't care. With good reason, they just don't have to pay for it themselves.
Yes, I understand, and that is correct, Your Honor. And so that is my first point. The second point that I want to emphasize is that Appellant's counsel has referred to the BOP expert as a so-called 3-in-1 expert who can write an interview, have access. And in this case, Dr. Koenig, who was the BOP expert, she never...
Absent this rule, is there a constitutional requirement of the appointment of such a witness?
No, Your Honor. And in fact, with regard to procedural due process, this was stated out in Baker, United States versus Baker at 843 and 844. His right for procedural due process, as also reiterated in Vitek versus Jones, a hearing, notice of that hearing, to be heard, to present documentary evidence, to call witnesses, to have an independent decision maker, to have a reasoned decision, and to have an independent advisor, not even an attorney. And that's the United States versus Baker laying out from Vitek versus Jones procedural due process. And that's procedural due process that he's absolutely entitled to, which he has, of course, not only under the Constitution. The statute and the Standing Order provides him
Do
with
you think
additional...
whatever the general standard of due process is, that it's lessened in this context?
No, Your
After a conviction, is it lessened or not? So I'm just wondering in your mind.
Well,
Because due process requirements aren't the same all the time at every proceeding, are they?
no, I would not say that it does. But what I would state that with regard to Baker was a civil commitment proceeding.
Right.
And that's why...
I was just asking about the general rule.
No,
The general rule is, I think that it's less is required at due process at a hearing like this than just absolute due process. But is your argument, if no witness is required, then a witness, but one you can't talk to and testify, even if their view is right, that can't possibly violate due process?
I'm not...
I'm saying if you're not entitled to a witness at all, can a witness with some limitations on it being provided, can that be a violation of due process?
No, Your Honor. That's not a violation of due process. And in fact, the other point I was going to make, Your Honor, is that Dr. Sala and Dr. Hoberman are court examiners. And that's the point I'm getting from the court here. These are court examiners. What the appellant seems to want to have is the ability to not only select an examiner, but to control and direct an examiner as if you're turning a court examiner into a Rule 26B4D consultant. And that's not the purpose of it. And in reviewing the recently submitted supplemental to the joint appendix, which cites the Coyle case, the court in Coyle makes a notation, and Coyle is at 2013 Westlaw 5508358 at 3. I'm referencing now. It talks about the potential liability that a Rule 26.4D expert has, as opposed to a court examiner. A court examiner is the court's witness, whether it is the initial court examiner or Dr. Sala.
I'm going to take you back to what you said earlier. You said under the operation of the old rule, and I guess you point to that language in the amended rule saying which respondent has always enjoyed.
That's correct.
That that third witness that could be appointed or provided to consult with ex parte communications with the respondent could testify?
That's correct. They had an opportunity to have this person.
But in this case,
They
the
did
record
not.
doesn't indicate that such a third expert was utilized and the court refused to let that person testify.
That's correct. There's no evidence of that in this case. And to Judge Hamilton's query with regard to Dr. Sala was a court examiner that was selected by the respondent. In fact, they moved for the appointment of Dr. Sala. And as Your Honor, Judge Shedd stated, they had an opportunity to consult with Dr. Sala. It just wasn't ex parte. That was part of what the magistrate judge ruled when they filed the initial motion seeking to clarify the examiner's role.
But it obviously couldn't be by deposition.
Oh, yes, even and apart from the Rule 26, if the purpose of this really is to just help you formulate questions, to conduct an examination, the other civil rules, interrogatories, the deposition, they had Dr. Koenig's report, they could have deposed Dr. Koenig, found out the theories behind her, the basis for her opinions, formulated their questions that way. So, I mean, if the purpose of this is to, in fact, help you design your questions for your examination.
Is there any bar in that rule to the government and the defense lawyer talking to that expert short of a deposition as long as they were both present?
Well, under the rule, if they want to talk to the court examiner,
Right.
they are going to have to move the court to allow that. And because
It doesn't have to be a deposition, does it?
no, it does not have to be a
They
deposition.
could just say, Your Honor, we'd like to have a phone call just to go over a couple of things with them, both sides, make a joint motion.
That's
It doesn't have to
correct.
be a deposition.
That's correct.
It
Nothing.
could be that the opportunities are presented for each side to talk to that court expert, but it's just both sides have to be present when that's done.
That is correct. It just bars the ex parte communications. Now, I believe that counsel also did make another argument with regard to the court's use of has my time expired?
No.
Okay.
We can barely see the lights on
I
that
can't-
thing in front of you.
You have 10 minutes.
Oh, okay. A lot more time than I thought.
Do you wish it had expired? Sometimes it goes slowly, doesn't it?
Sometimes it does go slower than you would think. With regard to the second argument, Judge, the district court did not abuse its discretion in allowing the testimonial evidence based on the uncharged conduct. The district court judge, well, first, they made a constitutional argument that was never raised before the district court judge to allow that district court judge to, in fact, rule on it, that argument. Therefore, we would argue that is waived. Second, all the witnesses, Dr. Sala, the court-appointed examiner that they selected, made extensive use of that same sort of evidence at 237 in the joint appendix, and 242 to 243, talking about, distinguishing about the uncharged crimes as well. In short, we believe the district court did not abuse its discretion, and we ask that you affirm the district court's order. Thank you.
Okay, thank you very much. Mr. Todd, you get a full 3 minutes.
I wish I had his 10, Your Honor. Moving right to our argument that the district court improperly used inadmissible hearsay as substantive evidence and relied upon that inadmissible hearsay, treated it as substantive evidence, and used that to make his decision. I quote from the court's final determination, when Ms. Shea says, "This entire case turns on whether or not the court credits the most recent allegations in 2003 and 2004, and how stringently the court wants to apply clear and convincing standard." That's from JA 299 to 300. The court's response, "Ms. Shea has hit it right on the head that just about everything in my decision is going to turn on those other what you say are allegations and what the government says are proved, and how far that goes towards meeting the clear and convincing standard." That was erroneous as a matter of law for the judge to use otherwise inadmissible hearsay, regardless of whether it can provide basis evidence for an opinion, to take that, treat that as substantively true, as substantive evidence, and the entire decision, commitment decision, by the judge's own words, hinged on that impermissible use. That, we say, is legal error, not just abuse of discretion. That requires a vacation of
What page are you reading from when you read that?
page 301, Your Honor. And-
Well, in fact, going to your hearsay argument, I think it fails to acknowledge that Dr. Saley, the respondent's selected examiner, also used the same hearsay information contained in a police report to conclude that Wood did not engage in repetitive acts of child molestation against a 10-year-old child, but committed only a single act, and is further weakened by the PSR, which Woods did not object to or seek to qualify in any manner, and it contained much of the challenge statements that you say are hearsay.
If I may quickly, Your Honor, Dr. Sala pointed out that it would be malpractice for him to rely upon that hearsay. That's why he cited that hearsay, because he, as an expert, could not reasonably rely on that. Second,
Well, was there any objection to the PSR?
yes, Your Honor. In fact, the supplemental JA that the government presented from the PSR back from Iowa, there's a whole list of defendant objections, and in there he denies the allegations. Your Honor, I have 20 seconds. The government has the burden.
Well, I would only suggest to you that the hearsay was admissible under Rule 702 and 703.
It would be admissible to rely upon as basis evidence for the opinion. Neither the expert nor the court is permitted to treat it as substantive evidence. 702 only permits it as a basis, but you cannot treat it as factually true. And especially in this case, the court cannot do that. That's just basic violation of how you can and cannot use hearsay. The government had the burden. I see my time is up, Your Honor.
Take 15
Thank you.
seconds.
Your Honor, Mr. Wood faced indefinite commitment in prison-like conditions, stigmatized for life based on this determination. The government had the burden to prove all three elements, not with a piece of paper, but with real competent evidence. They could have brought the accusers in, as they did in Burkhart, the case cited in Bartko. They could have brought the investigator in. They didn't, Your Honor. And the court, therefore, erred. We ask this Honor to vacate the commitment order and remand solely on the existing record, limiting the judge's use of inadmissible hearsay. Thank you.
Thank you very much. We'll step down, Great Counsel, and go directly to the third argument.